Hello, and welcome to this discussion on lockdown laws and the threats to our freedom. I'm Joshua Rosenberg. I'm a legal commentator, and I'll be chairing this event hosted by the RSA. I'm delighted to be talking to Adam Wagner, a human rights barrister and one of the UK's leading experts on COVID-19 laws. Adam practices from Doughty Street Chambers in London. He appears regularly on television and radio. And during the pandemic, he was often called on to interpret the bewildering array of COVID-19 regulations. Welcome, Adam.
Thanks so much for having me.
I should explain that we're recording this discussion a few days before it goes out. That doesn't stop you from sharing your thoughts and comments with us if you'd like to. Indeed, we encourage you to do that, but it does mean we can't respond or take your questions. If you're on Twitter, then you can use the hashtag RSA Freedoms. That's one word, RSA Freedoms. Now, Adam published this book on the 13th of October, Emergency State, How We Lost Our Freedoms in the Pandemic and Why It Matters. I said at the time that it was a book that needed to be written and nobody could have done it better. It chronicles 2 years of unprecedented restrictions, beginning with the very simple instruction given to the British people on the 23rd of March, 2020. You must stay at home. Well, that, as Adam points out, was not an instruction at all. It didn't become law for another 3 days. The request, the plea, I suppose you might call it, was given to the British people by Boris Johnson. Remember him? He was the Prime Minister who accepted a fixed penalty notice for breaking the lockdown restrictions. Now, many of those regulations were made by the then Health Secretary, Matt Hancock. You may have noticed that he himself was locked down last week. But for this discussion, I want to take things on a bit. We know that the government is very concerned about public protest, particularly about the Just Stop Oil protesters who block roads and prevent people going about their business. Rishi Sunak wants the Home Secretary and the police to do something about this, and there's apparently to be a meeting this week, though I can't tell you what the consequences will be because we're recording this on a Monday afternoon for transmission on Thursday. Now, Adam, going back to the 2 years of lockdown that you chronicle in your book, you wrote this year in the Times in September that although protest was never explicitly banned, the Metropolitan Police behaved as if it was. You also wrote that people should be given latitude to express themselves if they're doing it peacefully. I want to know from you whether that extends to blocking streets and preventing emergency vehicles from getting through.
Well, during the pandemic, we had this very strange situation where there was an effective ban on protest for really the best part of 2 years. There were three periods of lockdown, mostly in 2020 and in the first few months of 2021. The protest was never explicitly banned, but there was a ban on gatherings of 2 or more people outdoors for a significant period, and then slightly bigger numbers than that. And what effectively happened was that the police treated that as protest being entirely prohibited. And that went to court through the Sarah Everard vigil. I was acting for some of the women who were trying to organise that vigil. And the court said, well, you got that wrong because you didn't take into account sufficiently the fact that the Human Rights Act gives us a right to protest. I think there's a couple of things. One of the things I try and do in the book is just set out what happened, the really extraordinary things that happened in those 2 years, because I think a lot of those things people, lawyers or anybody, would never have imagined could have happened. I think the almost complete ban on the right to protest is one of those things, because I think before the pandemic, you would always assume that outdoor protest is, a kind of safety valve, that no matter what the threat, you would always have some ability to protest. And I think it's pretty extraordinary just on a factual basis that it appears that was wrong, along with lots of other things that you would assume could never be banned. But I think what we saw in the pandemic was a sort of preview of what happens when the police become more embroiled in the in what I think of as peaceful protests. And peaceful protests are, if they're on a large scale, do tend to be disruptive and obstructive. But if they're not violent, the law has generally in the past, not exclusively, but generally kept the criminal law away from those protests. Because of course,
I want to press you on that, Adam, because as you say, it's normally possible to protest. The lockdown restrictions are over. And the police are in a difficult position because on the one hand, you've got all these messages from government saying this sort of protest that we've been seeing in recent weeks and months is really going too far because it stops people going about their lawful business. On the other hand, you've got the police very aware, as you have said, that there is a right to peaceful protest and that shouldn't be banned. It does leave the police in a very difficult position immediately following their perhaps going too far in banning protests during lockdown.
Yeah, I think it absolutely does. The more the police are asked to come into these situations, which are essentially peaceful, which are they're really political actions. I mean, they are political actions, protests. They exist on a political plane. They're not traditionally public order. Now, that being said, if someone's blocking a road, it is there's a criminal offence of obstructing the highway, and there's been for a very long time. Been a statutory offence for obstructing the highway. So blocking the road is illegal. There are some limited exceptions where people are expressing a right to protest because traditionally protests have often, processions have taken place on the roads. So you will, just in the same way that, lots of things block the roads. Football matches block the roads. The coronation will block the roads.
Traffic jams block the roads, but what about if you block half the road? Is that lawful or unlawful?
Well, I think generally it's not lawful to block the road. It's just there may be exceptions. Now, I think what's going on with Insulate Britain, I think, and certainly the way the courts are treating it, is that the purpose of the Insulate Britain protest is obviously to bring attention to Insulate Britain as a cause, but as a tactic, the tactic appears to be we are going to block the roads to get that attention. So it's in terms of direct action, it's not very directed at all. It's directed at the public rather than being directed at the government or oil companies or that sort of thing. So I think the way the courts are treating it is, well, if this is protected by the right to protest, but it's at the far edge of the protection. It's at the it's not in human rights law we would say it's not at the core of the rights. And in fact, that's what the European Court of Human Rights has said about go slow protests on the roads. There's a case called Kudrivicius, which has been very important in the it was about Lithuania, but it's been very important in the UK protest law context, where the courts have said a group of protesters about something to do with farms blocking the roads were not at the core of the right. So it's entirely legitimate for the state to restrict those protests. So I don't think there's any issue in human rights law with people being arrested or prevented from protesting if the purpose of the protest is to block the road. But there may be some wriggle room around that when there's important causes which inevitably are going to block the road because you've got a big protest on it. So like everything in this area, it comes down to balance and it comes down to proportionality. And, if people getting very angry and sort of taking the law into their own hands or expecting the police to steam in and, and drag the protesters off the street like you see in Italy or France, I just don't think in this country it's going to happen.
Well, let's look at the Public Order Bill, which has been passed by the House of Commons. It's currently in its committee stage in the House of Lords. The Lords blocked these proposals during the last session of Parliament because MPs hadn't been given the chance to consider them. Now, the Home Office, in what are called explanatory notes, they say the purpose of the bill is to strengthen police powers to tackle dangerous and highly disruptive tactics employed by a minority of protesters. These include provisions to protect major transport projects and key national infrastructure from being targeted by protesters, causing significant delays to the travelling public, preventing the distribution of critical goods such as fuel, and causing costly delays in construction. Now, if that bill is passed by Parliament, and there's every reason to suppose that it will, then when that comes into effect, that will make quite a difference, I suppose.
I think it will. I think what it actually does, if you get into the nitty gritty of it, is it puts into statutory law what's been happening in the sort of civil injunctions, anti-protest civil injunctions. So lots of companies and government departments have been getting out these injunctions where they go to court and they say, well, the court will order that if somebody is protesting within a certain number of meters of a site entrance, say an oil, a fracking site or an oil refinery, or they lock themselves onto something, or they block the road around the area, or even if they just trespass, then they'll be in contempt of court, which could lead to up to 2 years imprisonment. And this is, on one level, it's turning those restrictions into criminal offences. But I think on another level, the thing that worries me about this bill is it really brings in a framework that's been used, a criminal law framework that's been used in knife crime, gang violence, drug crime. So there's a sort of set of tools, including sort of protest prevention orders, which is exactly what you get in knife crime or gangs, where once someone's been convicted of a couple of protest offences, which could just be aggravated trespass, very low level stuff, non-violent, they can then be ordered to stay out of a city centre or not associate with particular protest colleagues, or even be tagged for up to 2 years, which is exactly how you deal with knife crime, terrorism, that sort of thing.
These are serious disruption prevention orders. Is that what they're called?
Exactly. So it will target individual protesters, and they'll be inevitably the sort of harder core end of the protest spectrum, and the people who really, in my experience, will be willing to go to prison. You'll just get a lot, as you already are through the protest injunctions, you're going to get a lot more peaceful protesters in prison. It'll be in the hundreds, I've no doubts. The other thing that this does, which I think is really worrying, is just like you have with knife crime, if a senior police officer says that a particular area is designated as a zone where you can have suspicionless stop and search. So around, police could bowl into a very large protest like Extinction Rebellion, and if they've got this order in place, this direction, then they can stop and search people without suspicion, which can be hugely harassing. And they're not looking for knives or drugs. They're looking for glue and sellotape. I mean, quite literally, because they are the things they'll be looking for. The reason they say this is justified is because they're looking for the equipment that people use to tie themselves together.
What about bicycle locks? I mean, you can tie yourself.
It could be bicycle locks. It could be string. It could be duct tape. It could be super glue. And these are everyday objects. They're not, and they have they're very different to a knife or a spliff or something like that, which are more obviously for criminal use. So it could be really. Again, it's this thing. It's getting the police into situations which are nothing to do with public order, that are really to do with sort of annoyance or disruption, and they involve lots of people exercising their political rights. So I think it's very different.
But haven't the protesters brought this upon themselves? I mean, this tactic of locking yourself onto a fixed object or locking yourself onto another protester, this practice of tunneling to obstruct some building work. These are things we have seen. They haven't been specific offences. Can't we rely on the police to use their discretion and only use these powers when they're really necessary?
Yeah, well, I mean, locking on and tunneling are really very old tactics. I mean, Gandhi was a famous locker-oner. The suffragists had a tactic of slashing paintings to use, the thing that people are very upset about, the throwing soup at the painting. I mean, there was a suffragist who slashed the Rokeby Venus by Velázquez with a meat cleaver, took a meat cleaver into the National Gallery. So these kind of tactics, tunneling, I mean, we probably all remember Swampy, or if you're of a certain age, that was the original tunneling and creating bases in trees around Manchester Airport to prevent building of the second runway. And this stuff goes back a long time. So I'm not sure the protesters have brought it upon themselves. I think that there is but also, the aggravated trespass covers all of these situations. If you're in somebody else's land and you're obstructing lawful activities on the land, that's a criminal offence of aggravated trespass, which has just been put into on a statutory footing as well. So I think that the tactics themselves are the obvious response by the government is, oh, well, let's all make all those things even more illegal than they already are. But on the other hand, they are a traditional part and parcel of disruptive protest. And my worry is that what you're seeing is a kind of centrifugal force where the more extreme the restrictions are, the more extreme the tactics are, and the more extreme the punishments are. As I say, I've got clients now who are in prison right now for peaceful protesting. I've never had that before, and I've been acting for protesters for a long time. And that is going to increase and increase and increase as the cases go through the system.
While we're talking about public law, we should think for a moment about China. Large crowds took to the streets over the weekend to protest against the COVID restrictions. As we're speaking on Monday afternoon, we don't know what the authorities are going to do about what they must see as a dangerous challenge. But do you think that restrictions of some sort may still be justified in China?
Oh, it's incredibly difficult, this situation, because China's lockdowns were very different to ours. I mean, they had extremely draconian lockdowns and enforcement. When you look at lockdowns, you really look to enforcement. How strictly are they being enforced? And our lockdowns became ever less strictly enforced, to the point where in the second and third lockdown there were so many exceptions that it became very difficult for the police to enforce them. And most of the enforcement was against people, young men who were out and about, just sort of causing trouble on the streets, rather than anybody else breaking the lockdowns. And they were enforced much more strictly in France and Germany and Italy, as I say in the book. But in China, because they had already the authoritarian structure and surveillance system, they enforced them as strictly as they possibly could. People really did stay at home. And what that meant is that the COVID hasn't really taken off in China. They're still in the situation we were in, say, at the second lockdown in autumn 2020, when if they start relaxing restrictions now, the population is basically unprotected. There's not very high vaccination rates, so there's very low infection rates because they've had this zero COVID policy, which has been on one level in terms of its aim, it's been successful. But it's created a kind of almost semi-permanent emergency state, as I describe in the book. The state that's been distorted, that's been turned around in order to fight off a danger, but the result of which is that power has become hugely concentrated, even more so than it was. But the restrictions in place have massively restricted people's liberties. And I think the difference is that in most countries in the world, COVID got out anyway. COVID infected the populations. Pretty much everybody's had COVID many people more than once. And a lot of people have already died. The most vulnerable have already died. And so in China, they're still at the beginning in a way. And you're going to see, it's hard to see how it will be resolved without either some sort of popular revolution, or China just sort of doubling down on restrictions, or relaxing and then trying to figure out some way of handling the inevitable surge.
What you're saying, in effect, is that although the policy of herd immunity, which was mentioned at the very beginning of lockdown in the United Kingdom, was derided and then quickly abandoned, that's what we've got in the UK, really. People are vaccinated or recovered, and therefore they're relatively safe, at least compared with China.
Well, we landed somewhere in the middle in the UK and in most countries, in actual fact, that the restrictions could be maintained for a while, but only in short bursts. And once the vaccine came along and was widely taken up, in addition to the fact that lots of people got COVID, you could have some sort of imperfect middle ground where certain people were protected and managed to avoid, certain vulnerable people were protected and managed to avoid COVID. And at the same time, look, I mean, you still had many people died. I mean, the UK have had over 200,000 people died, which is a large, significant proportion of the population. But herd immunity, I think that to give a bit of the benefit of the doubt to, I think it was Chris Whitty who mentioned herd immunity at the time. He was just talking about the reality of the fact that, like it happened with every virus like COVID, in the end, nearly everyone's going to get it, and you can slow that down, but you can't prevent it. I suppose he wasn't thinking about a massively restrictive and surveillance focused and enforcement focused state like China, where, just to remind people that they've also got detention centers set up where they take people forcibly who have either got COVID or have been exposed to COVID. So it's just a really they have achieved true suppression of the virus, but the cost has been absolutely extraordinary.
So that's really what you describe as the emergency state. And you draw a distinction in your book between the emergency state and the state of emergency that was declared in the UK in February 2020. How do you define the emergency state?
So the state of emergency triggers the emergency state, but what the emergency state, by my definition, is what happens to the state when it reorganizes itself to fight an external threat. And that doesn't need to be a virus. It could be a war. It could be an economic shock. It could be a natural disaster. But generally speaking, you have to, even in the most democratic of states, you have to change things around for a bit. You lose the benefit of sort of detailed parliamentary scrutiny because you have to move really fast. You generally, in a democratic state, you don't concentrate power because you know what happens when you concentrate power. It leads to corruption and bad decision making when it's only, power is generally diffused. But in an emergency state, you have to concentrate power for a while, again, because you have to make decisions very quickly and ruthlessly. But it comes with downsides, which, such as I've mentioned, corruption. I think there's inevitably corruption when there's too much power focused into too small a number of people. There will also be poor decision making, and the longer you maintain this, the lack of scrutiny and the concentration of power into those few hands, the worse the decision making gets, because you lose all of the benefits of a democratic state where power is sort of diffused and power and there's a communication system that goes up and down from the ground to the top of the hierarchy. So the leaders know empirically and evidentially what's going on, and they can calibrate the policies according to that. But you lose all that if you have everything going through a small group of people.
One of the interesting points you make about the emergency state is that often we, the public, we actually want that to happen. Now, I think you're right to say that many of us will willingly accept restrictions if we think they're for the common good. Indeed, some of us might even urge the government to go further. But surely it's just the benefits of the emergency state we want rather than the restrictions. We want to be protected against the peril, war, plague, whatever it may be. But we don't actually want the emergency state to happen, do we?
No, it's a bit like when if you've got cancer, you don't want to have chemotherapy because it's a really unpleasant and difficult process. But you take it because you know it's for the long-term benefit of your of curing the disease. And the same way with an emergency state, I think we all know intrinsically, even if we've not been through a crisis like this, we know that you have to make sacrifices. In the Second World War, I look quite a lot at the Second World War as a comparison, because I think it's actually it's a really interesting comparison. Lots of secondary legislation intruding into the intricacies of people's lives, and lots of restrictions and very concentrated power. In the Second World War, the government said they asked people to lend their liberty for the war efforts. In the same way they were digging for Britain, going and fighting in the war, they would lend their liberties so that you could survive the Blitz and things like that. And I think people intrinsically know that, but they also psychologically, one of the things I wanted to capture in the book for later on, when 3 years down the line, when the COVID inquiry reports, and we all say in retrospect, yes, that was dreadful and that all went wrong. It's really important to remember how it felt to be in the middle of that crisis, and just the fear and the panic of not knowing what's going to happen. Is this how dangerous is this virus? How quickly is it going to spread? Are my relatives going to die? Am I going to die? Am I going to suffer from long COVID? All of that. We do want it to happen. We want someone to take control and to tell us what to do, and to do the right thing, even if it means taking risks and paying the consequences later. And I think that's it's incredibly important to remember when you're thinking back and you're wondering how could all this have happened, that's how it feels to go through a real threat and a real emergency.
It's very interesting because you remind us in your book of the laws that were made by Parliament, the regulations that were made by ministers, how they were introduced without debate, how they differed from the guidance that was given to the public, how they varied across the United Kingdom, how the police misunderstood them, how they were inappropriately enforced by prosecutors and courts, and of course how they were ignored by officials and ministers at the very highest level of government. But I don't know how it feels to you. I mean, it wasn't very long ago, but because it was so awful in every way that you've described, we've really tried to put it out of our minds. We've almost tried to forget that it happened, pretend it didn't happen. Is that how you feel, or is it still very close to you?
Yeah, a lot of people who read the book said exactly that, said, I can't believe it. I mean, it was only this time last year we were debating whether to have more restrictions because it was the Omicron outbreak. I mean, it seems like and it was only earlier this year that the final, on the 22nd of March, the final COVID restriction was removed. So this stuff really happened very recently, but psychologically, I think it was such a trauma that we all would quite like to forget. And I think the importance of remembering is to understand that all of those things that you mentioned, the overreach, the fact that Parliament just sort of took a back seat, I think a lot of those things can be insured against if for next time. I think it was excusable in a way that in this country, not in the certain Eastern countries, but in this country and in the West, we haven't experienced a major epidemic like COVID for 100 years, or we've lost the muscle memory of how to deal with all that. We used to experience them all the time for hundreds of years. You only need to read the Old Testament to find, how to deal with quarantine and that sort of thing. But I think that we will snap back into that kind of behavior if we come up against another pandemic. But certain things like that happen to our society, I think there's ways we can protect ourselves against ourselves for next time.
You also admit to having been troubled by a fundamental question at a time when lockdowns were a regular part of life for us all. What should you, as a human rights lawyer, have said at the time about them? How did you resolve that question in your mind?
I found it really difficult, and one of the criticisms that people have made of the book, such as Lord Sumption, is that it's who reviewed it and said it was very sort of powerful on the criticisms, but I didn't go far enough in criticizing the restrictions. It was really hard at the time. I mean, it's hard for everybody. I'm not saying it was hard for me as a lawyer, but just understanding what the limits of human rights law is. What can human rights law say about these almost unimaginably large balancing decisions that had to be made, not just by our government, but by every government in the world? What do you allow to happen? What do you leave down to guidance? How do you protect? Which groups do you privilege in terms of if there's one group over another? That just the most crushing example, I think, emotionally through the entire pandemic was the release of elderly people back to care homes at the beginning, towards the very beginning. And it's a decision which the government's been hugely criticized for, and in fact was found to be unlawful. But you could see, I having done an inquest quite recently into an ambulance worker that died at that very sort of in those weeks, and reading through all the decision making and the policies that the government were faced with, the health secretary was faced with. Well, on the one hand, we need to empty the hospitals because we're about to have a wave of people with a new disease that we've never had before, and we've got to have enough space. And on the other hand, you've got lots of vulnerable people who need to be protected, who are the very people who are most vulnerable, and they knew at the time, to catching COVID. So we're going to have to send them back to their care homes, but in a safe way. And probably they didn't do it in a safe way, but you can see that decision of having to choose one bad choice against another bad choice. They're kind of inherently policy decisions, and really hard to say on incomplete evidence. Well, what's the right, you can't put it into a sort of human rights machine and say this is the answer. Maybe in 5 years, maybe in 10 years, there'll be a consensus and say, well, this was wrong and this was right, and lockdowns were wrong, but curfews were right, or quarantine was right, etc., etc. But I never was able to. I always felt sort of inadequate to the task of saying conclusively, this is the answer, this is what we need to be doing policy-wise. But that's not to say, the book does deal with lots of individual policies, such as hotel quarantine, the bans on protests, the ban on worship, the fact that the sex was sort of almost accidentally banned between people who weren't living in the same house for over a year in parts of the country. I do look at all those issues and try and understand whether there is an answer, but this sort of big unifying answer to the question, what were we meant to do when COVID struck, I don't think is there yet.
And Adam, of course, you're a human rights lawyer, and human rights lawyers are accused by certain people, particularly the government, of objecting to just about anything that governments try to do. There's a case on at the moment about how quickly somebody gets treatment for certain conditions, also all that sort of thing. So, human rights lawyers are not slow in coming forward. But what struck me as most interesting is there were no significant challenges to the lockdown regulations in the courts, or certainly none that were successful, none that troubled the government. Why is that, do you think?
There were lots of challenges, and I acted in quite a lot of the challenges, but the courts set their stall out in the Dolan case pretty early on. So I guess that was in the summer of 2020, leading to the autumn when it got dismissed in the Court of Appeal. The court very, very clearly put the foot down. The Lord Chief Justice gave the judgment and said, this is not for us. These policies are inherent, just what I've just said, they're inherently matters of social policy. They cannot be, even though there's lots of human rights elements to them, we're just not going to go there. And I think my worry, but I compare that decision to the famous Liversidge and Anderson case during the Second World War, when, there was no dissent in Dolan, amazingly. There was no, bearing in mind, Dolan was a challenge to the regulations, the biggest restriction on people's rights since the Second World War. That's what the permission, the judge who gave it partial permission, I think he just, Lord Justice Hickenbottom just said there needs to be a rolled up hearing. So I don't think he gave it permission, just said, wow, look at this. The court just said, well, it's not for us. And even in Liversidge and Anderson, which was the equivalent case in the Second World War, when the defence regulations, which allowed for indefinite detention on the nod of the Home Secretary, there was a famous dissent by Lord Atkin who said, even amongst the clash of arms, the laws are not silent. But there was nothing like that in the pandemic. There was really just a sort of universal, we're not dealing with this situation. And I think, at the very least, I think the court should have considered those cases at a full hearing and thought through, the question of, for example, whether the Public Health Act allowed for such extreme restrictions, which were never envisaged in specific form when the Act was being changed in 2008. And I know that because I've read the debates, and there's nothing about lockdowns, and there can't have been anything about lockdowns because there had never been a national lockdown in 2008. The first one, I think, was in 2009. So I think there was a huge amount to do and to look at in terms of proportionality, in terms of whether the restrictions were permitted by the primary legislation which created the regulations. And the courts just sort of ducked it, really.
And the man who brought the case, Simon Dolan, who was a public-spirited individual, he ended up having to pay the government's legal costs to some extent, I think. I mean, either he misjudged the mood of the courts or the courts misjudged the mood of the public. What are the broad lessons? This is really the final question to you, Adam. What are the broad lessons that we should learn from lockdown and take forward now? Things, at least in in the Western world, not clearly in China, things are recovering and people are still ill, but we don't have these restrictions anymore.
Well, I think in the UK we have to look at the fact that even if the restrictions were broadly correct, and I'll leave that to the COVID inquiry to decide, there were 109 regulations which created all of the restrictions, travel restrictions, self-isolation, hotel quarantine, COVID passes, and the lockdowns and the gathering bans. Of those 109 regulations, only 8 of them were debated in Parliament before they came into force. Usually the day before, usually Parliament had been given a few hours to read the regulations, to digest them. And the regulations, not a single one of those 109 regulations was amended, because there was no way of amending them, even though if this had all been done under the Civil Contingencies Act, which is what happens, what you use if there's any kind of disaster apart from public health, the Parliament could have amended the regulations. I think it's important to understand that there was no, Parliament basically took a back seat. And at the same time, the courts, as I've said, took a complete back seat. Unlike in lots of other countries, the courts were intimately involved. In France, the Constitutional Court overturned 50 lockdown laws. In Spain, the entire first period of public emergency was struck down, and they had to pay back all the fines because it had not properly been justified, the public emergency under the Constitution. And there's lots of examples like that. And I think that I'm not saying that we would have had a really great experience of the pandemic if the courts and Parliament had been more involved. But I think we have to see as a warning sign democratically that the government was allowed, and I say the government, it was really only 4 men. It was Boris Johnson, Rishi Sunak, Matt Hancock, and Michael Gove, who sat on the COVID cabinet committee. They made all the decisions. They were totally, almost totally unscrutinized, almost totally unaccountable. We've not spoken about Partygate, but there was a huge sort of behind closed doors breaking of the rules. And there was also the very troubling VIP lane stuff where, I think £4.8 billion worth of public contracts were given to people who had contacts with Conservative MPs and Lords. So all of this going on at the same time, I think that emergency states are a danger time for societies. We need to protect ourselves from corruption, from bad decision-making as much as we can. And the ways to do it are, well, first of all, read the book. And then second of all, think about ways to protect ourselves in the next emergency.
Adam Wagner, that's been a fascinating conversation. I'm afraid that's all we have time for now. Thank you so much for talking to us today. Adam's book, Emergency State, is out now. The RSA have provided a discount code for anybody who buys it through Foyles Bookshop. The code is Foyles RSA 20. Foyles RSA 20, and I think that code and a link to the book should be appearing in the live chat as we speak. Thank you very much for watching. Thank you to the RSA for hosting the event. If you'd like to learn more about the work of the RSA and how to get involved in their global fellowship community, you can visit the RSA, all one phrase, .org. Thank you very much for watching, and goodbye.